Hello and good morning, everyone. It is 9 o'clock and we will get started. Well, we're starting to see people slowly come in, and I'm just going to talk a little bit more just to give people a second more of time before we start the webinar. We want to welcome you to another Educational Bender U webinar discussing the 2023 New Year, New Employment Laws, What You Need to Know. Some housekeeping notes. If you have any questions during the webinar, please feel free to type them into the chat box or in the Q&A section. We'd like this to be an interactive experience, so our presenter will be available to answer your questions in real time throughout the webinar. During our additional Q&A time at the end of the presentation, I will be sharing other questions you might have with our speaker. We want to be conscious of time, so if we don't get to answer all of your questions, we will gladly reach out to you individually after the webinar. You are in listen-only mode and will remain muted throughout the presentation. This session is being recorded. At the conclusion of the webinar, the recording link, as well as a copy of the slide deck, will be forwarded to you. My name is Keck Royce, VP of Healthcare Risks with Bender Insurance Solutions. I've been with Bender for 10 years. I help guide organizations to become an employer of choice while protecting their assets here at Bender. We have an incredible expert sharing with us this morning. Aaron Silva is a partner with the Labor and Employment Practice Team for Murphy Austin. He has an extensive background defending employers before state and federal courts and several administrative boards. In his counseling practice, Aaron advises companies in all areas of employment law, including employment, classification, employee termination, leave decisions, union matters, and drafting effective and enforceable employment policies, as well as performs management training in the areas of avoiding discrimination and other public policy violations. Aaron was awarded his JD from the University of Davis School of Law. Prior to joining Murphy Austin, he worked for both the Cal-OSHA Appeals Board and the California Public Employment Relations Board. He was named a Rising Star by Northern California's Super Lawyers magazine in 2013 through 2021 editions, and was named to be the Sacramento Business Journal 40 Under 40 2026 list. Without further ado, I welcome Aaron Silva.
Well, good morning, good evening, good afternoon, wherever, and because this is being recorded, I suppose whenever you may be listening to this. Thank you for the introduction. One of the key things of an introduction is getting the presenter's name right, and my name was right. I'm Aaron Silva. I'm a partner at Murphy Austin. I'm actually the chair of the Labor and Employment Group over there, and we're doing a presentation today about new laws for the new year of 2023. So, we start off every presentation, because we're lawyers, of course, with some sort of legal disclaimer. So there you go. You can read that at your leisure. I'm sure all of you will digest it, have fun with that. If you want to see what I look like, that's what I looked like when a picture of me was taken. It's certainly not what I look like right now. There are good things and bad things about doing things remotely. I mean, being in person, I get to see my audience and see their reaction, and I enjoy doing that. But being remote, of course, you get a bigger audience for the most part, but you don't have to look like that at least, or at least dress up. So before we get into the presentation, just a little housekeeping. You are more than welcome during this presentation to ask any questions that you want. I prefer that you ask your questions as the presentation is going, because it makes at least the question, in my opinion, a little bit more relevant, because we're presenting on that, and it might spur other conversation topics from that. So please do not hold back. If you want to wait until the end to ask any of your questions, you're more than welcome to do that as well, but I prefer doing it as we're going through the presentation. Now, I did get a chance to see the list of individuals that are attending today. So it's a general list of employers. I would say that it probably leans towards contractors, but today's presentation is really a general presentation of laws of general applicability that are employment related. So there certainly are some employment or some industry specific laws that were passed that I'm not necessarily going to go into. For instance, there were some Warren Act things that were specific to call centers. I didn't see any call center clients on this call, and excuse me if you are, but I'm not going to cover that because that's just too narrow. So this is more general applicability. I will say for my contractor audience out there, if you are interested, my construction partners, so Murphy Austin is a full service firm, we're a business firm, so we have a business department, real estate department, probate, general lit, of course, labor and employment, but we also have a very big construction department. And two of my construction partners, Scott Alexander and Ken Schumacher and myself always team up to do a separate vendor U that's specific for contractors. So they cover like the first half where they're talking about construction laws and what's happening in their world. And then I come back and I deal with employment laws that are specific to contractors. So if there's something new with like prevailing wage or something, that's where I typically hit it. So I'm not going to talk about prevailing wage today, but if you're interested, keep your eyes out for that. I think the date is February 2nd. And again, it's another vendor U. All right, so why don't we jump into the material today? We're going to start with what is the most popular topic in labor and employment law, wage and hour stuff. So let's start with the most basic stuff. It changes every single year, and it's changing this year. It's the 2023 minimum wage. So it is now $15.50 an hour. Now, there used to be two thresholds that were going, depending on the size of the employer, as to what the minimum wage needed to be paid. At a certain point in time, that was going to be merged into just one minimum wage. We are now at that point. So $15.50 an hour for the minimum wage. Now, you may be thinking, that doesn't really affect me because I don't have any minimum wage employees. Well, if you have exempt employees, it does affect you. Why does it affect you? Because under most of our exempt status tests, to be an exempt employee, the employee needs to earn a salary of not less than 2 times the state's minimum wage on a monthly basis. So if you see that, that is the exempt salary threshold, which is now $64,480 a year. In other words, if you have a exempt employee that is making a salary of less than that amount, you need to question whether or not that person is actually exempt or not. I do want to emphasize with exempt status, because we're talking about it very quickly, that exempt status is more than just salaried versus non-salaried. Now, if you don't know what exempt status means, is it's certain individuals, usually higher compensated individuals, that are exempt from various state laws, specifically laws about being paid overtime and breaks. There's a few other things, but those are the main highlights. So to be an exempt employee, some people just assume, well, if I'm paying someone a salary, they're salaried employees. And if they're a salaried employee, that means that they don't get overtime and they don't get breaks. That's not true. It's much more complex than that. Certainly being paid a salary is an aspect of exempt status, but there's also many other factors that are involved in doing that. So for instance, the most popular exemption in California is the administrative exemption. And there are certain requirements, like there's discretion that needs to be used by that employee in performing their jobs. And effectively, that's a white collar type job. So my point being is that when you're looking at exempt status, it's more than just salary. But salary certainly is an aspect of that. And because the minimum wage went up, that salary requirement has been affected. So be mindful of that as you go on. And of course, certainly this year as well. Next slide is about booting up computers. So here was the scenario. This is a federal law or a federal case, and it's interpreting a federal law, the Federal Labor Standards Act. So in California, for the most part, California is much more protective than federal law. So when it comes to employment law, for the most part, I don't really, I'm not going to say that it's not binding. It's certainly binding on us, but because it's less protective than California, I don't really do a lot of federal laws in and of themselves. I do practice in front of federal courts, but for the most part, because California is more protective, I'm not really looking at court cases that are interpreting federal law. But this one was very interesting, and it does piggyback on a California Supreme Court decision about a state law that we got a few years ago. So here are the facts, basically. Under the Federal Fair Labor Standards Act, that is the law that regulates payment for most employees here in this country. Time spent on activities that are an integral and indispensable part of principal activities is compensable. So here were the base facts in this particular case. An employee comes into work. They start up their computer. They're waiting for that computer to actually load up. Now they can log in, and now they can clock in. Is that time that they're waiting for the computer to start up and log in, is that brief amount of time, whether that's 30 seconds, a minute, whatever it is that compensable? And in the reverse side of things, at the end of the day, the employee clocks out and now they're shutting down their computer and they're waiting for their computer to shut down. Is that time in and of itself compensable? Well, in this particular case, that time waiting to boot up and waiting to boot down was something that was integral to the employee's work. They needed to use their computer, so they actually had to turn it on and they had to turn it off. So in this case, which was decided by the Ninth Circuit, the answer is yes. That employee or that time was compensable. That time needed to be paid by the employer. For the Ninth Circuit, the test was whether employees could eliminate the required activity, so in this case, turning on and turning off their computer, and still perform their principal duties. If they couldn't do that, if they couldn't eliminate that function, turning on a computer and turning it off, then that activity was integral and indispensable to their principal duties, and it needed to be paid. So I did say that this was somewhat of a piggyback to California law, and here's the reason that I say that. Several years ago at this point, we had a California Supreme Court case that dealt with Starbucks employees. And in the facts of that case, these Starbucks employees, these were the baristas. So they were closing up shop, and then they actually had to walk from their computer or from the register where they were clocking in and out. So they clocked out. So they're walking from that electronic device, and now they're walking to the door, and they are locking the door as they walk out to go home. The question was that time between the time they had clocked out and they had gone from their electronic device to locking the door, was that compensable? And being California, if you're going to take a guess as to what the answer was yes. It was compensable according to the California Supreme Court. And it didn't matter the minimum amount of time it took to do that. Why, according to the California Supreme Court? Because, yeah, maybe it's just a minute today to do that, to go from the electronic device to locking the door. But that's just a minute today. That's 5 minutes, assuming that person works 5 days this week. And that's assuming that they work the entire month, 5 days a week. That's 20 minutes that they're not being compensated for. And then you take that out to a year, and you take that out to 2 years. And their point is that if you add up that time over time, that becomes actually a measurable amount of money that could pay off something. The example they gave was a utility bill or something along those lines. So here's the takeaway of all of this stuff. When are your employees clocking in and when are they clocking out? Are they doing things before they're clocking in or that they're clocking out that they're not recording and they're not being compensated for? If that's happening, you need to be mindful of it. And you need to really analyze whether or not that time needs to be compensated. So I see this in the office scenario all the time. You know, it's basically the facts of this case, right? Someone to clock in and clock out, it's, you know, through some sort of payroll service or payroll program that's on their computer. So they got to turn on their computer to actually get to the point where they clock in. For you construction folks, I see this happen all the time where someone is coming to a shop or something, and you actually have the old school punch cards, right? So they actually have to walk in. They have to go to like a some sort of like break room or something along those lines, and they have to clock in and clock out. That's fine if they're not doing anything as they're walking there or walking back. But I've certainly had construction cases where the argument from the employee is that as I'm going to that time clock, I'm talking to my supervisor about what I'm going to do that day, or someone is asking me to help load up their truck or tie something down. They're doing something before they're actually clocking in. And I guess in the reverse in the construction industry is clocking out, right? They clock out, and then as they're walking to their car, someone's telling them what they're going to do tomorrow, or someone is asking them for a hand to unload the truck or put supplies on for the next day, whatever it might be. Point being, for that sort of time, you need to be aware of what's going on and determine whether or not you need to compensate for that time. Because this sort of scenario right here, this is the classic class action or PAGA type scenario, and we'll talk about PAGA in a little bit.
Aaron?
Yep.
We had a question come in. Can owners of the company be salaried yet not meet the exempt salary threshold without consequences?
Well, it really depends on whether or not you're strictly an owner or not. If you're an owner, but you're giving yourself a W-2, probably not. So that's the real basic test that I look at. It's a little bit more involved of an analysis. But my first question always in that scenario is, are you giving yourself a W-2 at the end of the year? And if you're giving yourself a W-2, you really need to look at whether or not you're exempt or not. Now, here's the thing. If you're the owner of the company, presumably you're not going to sue the company, right? Now, of course, if you're one of several owners, it's possible, or maybe you're in the scenario where you have other owners that are in that scenario. Maybe you have some sort of bad breakup, and all of a sudden, even though you were an owner, or I should say one of your colleagues was an owner, or maybe you're in the scenario where you leave and you're in the bad breakup. All of a sudden, hey, it was a bad breakup. I've got some ill feelings, and you know what? I was an employee, and for whatever reason, I didn't meet the exempt status or whatever it is, and I didn't get my breaks or I didn't get my overtime. So to answer your question, the first thing I always ask in that scenario is, are you getting a W-2? If that's the case, you should be mindful of it. For the most part, you probably, if you're an owner of the company, you probably should meet one of the several exemptions that apply for the most part. I mean, I can't make that blanket assertion, of course, but I mean, there's the professional exemption, there's the administrative, there's an executive exemption that applies for hiring and firing type decisions. So yeah, likely kind of will probably apply, but obviously you have to do that analysis. But that's always my first question. Is that owner getting a W-2? So that's the real basic question, and then we get a little bit more involved. All right, unless there's another question, discrimination, harassment, and retaliation. No retaliation against workers for leaving the job during some sort of state of emergency. So from what I can tell, this is a wildfire law. So here's what's going on in this law. This law prohibits employers from retaliating against employees for not going to or leaving work when they have a reasonable belief that it's unsafe because there's some sort of emergency condition that exists. In addition, employers cannot, when there's an emergency condition, prohibit employees from accessing some sort of communication device to either communicate to or get a communication from someone about where their whereabouts are and whether or not they're safe, and to just access any sort of safety information. Now, what's an emergency condition? Because that's what this law is all contingent upon, emergency conditions existing. So an emergency condition is a disaster or extreme peril that's caused by nature or some sort of criminal act. Another emergency condition is when there is an order to evacuate from work, home, or a child's school. So, you have an employee and their child's school is being ordered to evacuate due to some sort of natural condition or some sort of criminal act. Again, I think that this is a wildfire law, which is happening here, and I suppose that some employers were not letting people leave, presumably to go home when there was some sort of wildfire. I don't know, but regardless, this is a brand new law. It is something that you need to be mindful of, and again, it's all based on a reasonable belief of an emergency condition. So, what's an emergency condition? Well, perhaps you saw the mid-1990s movie Dante's Peak, starring Pierce Brosnan. Now, perhaps you didn't see that movie. And if you didn't see that movie, you made a wise decision because it's not a very good movie. But in that movie, it's about a town called Dante's Peak. And in Dante's Peak, over the course, I believe, of one day, there's an earthquake. There's a volcano that begins to erupt, hence the name Peak. And because of the heat generated by the volcano, all of the snow in the mountains melts, causing a flood, which causes a dam to fail, all putting the town of Dante's Peak in extreme peril. That, my friends, is an emergency condition. Luckily, if you're not going to see that movie, Pierce Brosnan was there and he was able to help deal with that situation and in the process find love. So in various avenues, that's a very successful story. Obviously, that's an extreme example, but in my mind, emergency conditions, and obviously I'm joking around a little bit there. Emergency conditions, it's some sort of wildfire, because that's what I think this law was about. But think about it. It's a natural disaster. So could the weather that we're having currently, and if you're listening to this as a recording, this is when we have several atmospheric rivers going through California. Could it qualify? Absolutely. I mean, we've had evacuation orders in place. So just be mindful of this new law and be mindful of how you're treating employees and what you're allowing them and not allowing them to do. So hopefully this isn't a big deal for most of you, but be aware of it. Okay, this year from the legislature. There have been very active legislature years as far as what they're doing with employment law. There are years where it's not so active and somewhere in between. This year, I'd say it was an in-between year, but there's a couple of significant laws that are out there. And in my mind, this is probably the most significant law because in some way or another, it affects every California employer. It's our pay transparency law, SB 1162. So there's two parts to the law. The first part only affects employers with 100 or more employees, so I'll go over that very, very quickly. So employees with 100 or employers with 100 or more employees must submit pay data both to the feds, but this is specific to the state, but also report to the Civil Rights Department of the Business Consumer Services and Housing Agency. Now, perhaps you've never heard of the Civil Rights Department. Well, the reason is because it didn't exist, or at least it did exist, but not under that name up until this year. That is previously what was previously called the Department of Fair Employment and Housing. That has been renamed by the legislature to the Civil Rights Department. So if you ever see that being referenced, they're talking about the Department of Fair Employment and Housing. That phrase should start being phased out in any sort of online postings that you're seeing, but that's what it's referring to. It's the same thing. But anyways, these employers for 100 or more employees need to submit pay data. Now that pay data has to include median and mean hourly rates for a combination of race, ethnicity, and sex within each job category. And there is a sample template that can be used, which would be helpful for you employers that qualify under this portion of the law. And there's the website to go take a look at it. Now, this also applies to employers with 100 or more employees hired through labor contractors. You also have to submit this report. Now, I don't know if this is easy or not, or the thinking here, but these reports are due annually before the second Wednesday of each May. So for whatever reason, that's the date that was chosen. Mark your calendars. Now, here's the more significant part of this law, in my opinion, because it has more general applicability. Employers employers of any size, I should say, must provide the pay scale for a position upon reasonable request by an applicant or by a current employee. So if you have a current employee or applicant come up and say, hey, what is the pay scale for the position that I'm working in? You're now going to have to provide that information. Now, employers with 15 or more employees must provide pay scale information in a job posting. So that is incredibly significant. So if you are advertising for a position and you have 15 or more employees, the general information that you have in there is now going to have to include pay scale information. Now, maybe you're thinking, I'll just use a third party to do that, so I won't do it directly. Well, the legislature is one step ahead of you because employers that do use a third party to announce, post, publish, or otherwise make a job posting available publicly must also provide that pay scale information to the third party, and the third party has to use it in the job posting. Now, like many things, employers have to maintain several types of records here in the state of California. I'm thinking of safety records, I'm thinking of pay records, but it is a long list. And this is also something that's going to be added to that list. Employers have to maintain records of job title and wage rate history for each employee throughout their employment and 3 years after their employment ends. So hopefully you're storing your documents digitally, or you just have a very big file cabinet. Now, what is a pay scale? Pay scale means salary or hourly wage range that the employer reasonably expects to pay for a position. Now, I've done this presentation, I don't know, 7, 8 times at this point. One of the first times I did this, I had the question of, well, why don't I just advertise for like, you know, a receptionist position that the pay scale or the pay range is $1 to $100,000, and I'll get around this law that way. Well, that's probably not a good idea because if you're advertising that your receptionist position can make up to $100,000 a year, and you don't intend to do that, that certainly is not complying with the spirit and intent of this law. So that just breeds problems with the state and compliance issues. But it also might have your receptionist asking, or current receptionist staff asking, why am I not on the upper scale? I've been here for 10 years or whatever it might be. So you're not going to outthink this law by doing that. Now, since the law was passed, or actually I should say within the last few weeks, because I think it was December 30th, the Labor Commissioner has posted an FAQ section on their website about this particular law, because there's going to be a lot of wrinkles that need to be dealt with this law because it's so brand new. So here are a few highlights that the Labor Commissioner is highlighting in that FAQ section. It only has to be pay scale that's advertised. So additional compensation or other tangible benefits don't necessarily need to be advertised or need to be provided under this particular law. Now, if you have a set hourly rate or some sort of piece rate, so it's set, it's not going to deviate. I'm only going to pay you $17 an hour for anyone that ends up having to fill this job, then you don't need to post some sort of range. But of course, that assumes that you have a set piece rate or a set hourly rate. Now, some employers might think that perhaps you could just do in your job posting, you could do a QR code or some sort of link that would provide this information. So what the applicant is seeing out in the public initially is just a job advertisement, right? And if they want to learn more about these details about pay scale and stuff, just click or just scan the QR code or just click on this link. That's not going to work. That is not sufficient. It needs to be in the job posting itself. So unless we have other
Aaron,
questions. Yeah,
we
I
do
figured
have
this
some
is,
questions. We do
oh,
have some
surprise,
questions.
surprise, surprise. Yes, let's go.
So let's start with one that I think will be an easier question to answer, and then we'll go to the next one. Can
Right.
employees request a job scale for any company position or only their current position?
Just their own, just their own.
Okay, I figured that would be a quick answer. The
So that
other
implies that this one's going to be much more difficult. I can't wait.
one,
Let's
no.
go.
The other one is 100 or more employees. Is that an average over the year or total hired or total employed at the time of the or total employed at the time of the end of the year? And in
That's a,
addition to that, there's a slightly in conjunction to that is same question, how many count of total employees, but we have a number of temp employees. So at any one time, we only have 50, but overall we go over 100. So that
yeah,
I think both combine.
so that's probably what the Labor Commissioner may be addressing that. I can tell you how, so I'm going to give you an answer which I assume is the answer. But do not pin me down that this is definite because I'd have to specifically look that up. Here's how it works with other laws, and I would assume that it probably works in this situation as well. Did you peak out at 100 or more over the course of that reporting year? That's how I think that it is, but I would need to verify that. I don't know that off the top of my
Okay.
head. Okay.
And then we have one more question that came in.
Yep.
We have an average rate of pay, but also have an exceptional rate depending on dynamics of household, senior care. Do we need to include the highest amount?
Well, if we're looking at what a pay scale is, it's the salary or hourly range that the employer reasonably expects to pay. So the question is, would you reasonably expect to pay that higher amount for whoever you fill that spot? And if the answer is yes, then no. I mean, if it's, someone that's been there for a couple of years and then you give them, a huge, some sort of huge jump because they just happen to be an exceptional employee, presumably not. But again, this is one of those things where we'll have to see how it plays out because this is a law that just took effect because where are we at? January 11th. It took effect 11 days ago, right? We don't have any regulations on it. We don't have any case law on it. All we have is this FAQ section. So essentially it is, do you reasonably expect that that's what you're going to pay someone in that position? And if the answer is yes, then you're going to have to advertise it. As of this point, of course, that can change as we get more interpretations of this particular law, but that's the general take that I have.
Yeah.
All right.
Then another question. There's lots
Yep.
of questions coming in now.
Okay.
How would performance-based comp fall into this law?
Well, I guess this is one of the downsides of doing this remote, right? Because my follow-up question would be, what is performance-based comp? If it's piece rate, I mean, again, and that's what I presume that it is. If it's piece rate, if it's just one piece rate, that's what, like I said, on the Labor Commissioner's site, it says that if you're just going to offer one sort of piece rate, that's what you're giving them. You're giving them the piece rate formula, and that's what you would use.
Or
Next one.
maybe compensation like for sales, like who
Well,
their
again,
job is based on.
Commission would presumably fall within that same sort. You're right. I mean, at the very least, if it's some sort of commission arrangement that you have, pre-existing is the obligation for any commission employee that you're going to have some sort of agreement as to what that's going to be. So, yeah, if it's commission, I would think that it would be the same as a piece rate.
Okay. And then one more. Would creating more different positions improve flexibility in navigating pay ranges for existing/new employees?
Well, yeah, I mean, if you have very distinct positions, right? That probably would be one way to deal with this and make it a little bit more manageable. But again, that assumes that the positions are distinct enough that they would justify effectively having their own category, if you will. Okay?
That's it.
Okay. Yeah. Okay. So medical marijuana. So how did, or not medical marijuana, marijuana. How did we get here? We got here with medical marijuana. So let's go back in time to 1996, Proposition 215, which made medical marijuana legal in California. And then we jumped to 2018. And we had this California Supreme Court case that ultimately decided that employers could require pre-employment drug testing and consider the use of illegal drugs in making employment decisions. In that case, back in 2008, the Supreme Court said, yes, we understand that medical marijuana is legal in California, but at the end of the day, marijuana is still illegal under federal law. So there is no need under our EEO law, the Fair Employment and Housing Act, FEHA, which does have a reasonable accommodation requirement for disability. There's no need to reasonably accommodate someone by allowing them to use an illegal drug as a disability under that particular law. That was 2008. Then we get to 2016. 2016, we make an even bigger jump with Proposition 64. And what does that effectively do? It legalizes marijuana in the state of California. Now, there's a carve out in Proposition 64 for employers that says if you want to make marijuana illegal in the workplace or pursuant to your policies specifically need to say that, which is one of the several reasons why you should have a handbook or have employment policies in place. But that's where we're at in 2016, and not much has happened until now. We have AB 2188. Now, importantly, this law takes effect January 1st of 2024. So it's next year, not this year. So you have a year to prepare for this. But what does it do? It makes it unlawful for an employer to discriminate based on a person's use of cannabis, quote, off the job and away from the workplace, unquote. Or for the employer to have a required drug screening test that detects the presence of non-psychoactive cannabis metabolites in their hair, blood, urine, or other bodily functions, right? So what does that mean? Basically, it's testing for marijuana use that happened some period of time before the employee was at work, right? It's not immediate. It's something that happened last week or 2 weeks ago, whatever it might be. Now, there are some exceptions, and for a good amount of this audience, that exception is going to apply to you. It's for employees in the building and construction trades and employees that are subject to other testing or security requirements required by federal law. Now, a couple of questions that I have gotten, so I'll try to deal with them up front, is no, this law does not require that you allow employees to use marijuana at the job site. So you do not have to allow that, right? Still, you can have a drug policy in place, which if you have that in place, it needs to be in writing. If someone is showing up to work and they are intoxicated or they are somehow inebriated, whatever it might be, right? And they're not able to perform their functions, you can still have a policy that is addressing that. You can still have a policy that if you have what is called a reasonable suspicion of alcohol or drug use, and it's affecting the employee's performance, you can still require that employee to do a drug test, and you can still take disciplinary actions because of that. Obviously, you need to look at the actual details of the results that you get, but you can still require that. What this law is going to require for most employers to do that do have drug policies in place and drug testing policies in place is to really work with whoever your provider is of those tests to determine how do we conduct these tests so that we don't run afoul of that second bullet point. How do we do these tests so we're not testing for use of marijuana that happened a week ago or 2 weeks ago? That's going to take a little bit of brain power. And I would assume that the providers of drug tests here in California are going to be mindful of that. But it's a conversation you're going to have because at the end of the day, if you just send someone off for drug testing and the provider's doing an unlawful drug test under AB 2188, that's going to come back to you. So those are the highlights for marijuana discrimination. Any questions on that one? All right. New required EEOC poster. So if you're an employer in the state of California, you probably have a room, whether it's a break room or some other room, where instead of having wallpaper or it's just a nice layer of paint, the entire room is just effectively has wallpapers of legal notices that are on there. And this would be one of them. So it used to be that the EEOC, so that's the Equal Employment Opportunity Commission, that is the federal agency that regulates and executes on the nation's EEO laws. So think of things like the ADA, Title VII, things along those lines. But they did have a poster that was required. It was called the EEO in the Law poster. Well, that has now been changed to the Know Your Rights poster. And here are some things, here are some highlights in these bullet points. It uses straightforward language and formatting, which that is actually in the press release. So that would imply that the old one didn't have straightforward language and formatting. But regardless, now we have one that does. It notes that harassment is prohibited form of discrimination. That is nothing new in California. It has always been. Clarifies that sex discrimination includes discrimination based on pregnancy and related conditions, sexual orientation, and gender identity. Once again, that is something that in California is nothing new. And it also adds a QR code for fast digital access to how to file a charge webpage for the EEOC. So now you are posting a poster where there's going to be a QR code where your employees can quickly learn how they can file a legal claim against you. There's also information on this poster about equal pay discrimination for federal contractors. So that is our highlights for EEOC posters. Any questions on that? Okay. Leaves of absence, always an interesting topic, always a complicated topic, but some of them aren't so complicated. This one won't be. Bereavement leave. Bereavement leave. So, you know, someone in someone's family dies, they need to be out for funeral or final arrangements, whatever it might be. Many employers, not all of them, had voluntarily created bereavement leave policies. You know, you can be gone for a week or 2 weeks or whatever it is. But the point being is it was all voluntary. Employers were deciding whether or not this was a benefit that was going to be provided. Now you don't have that discretion. AB 1949, this law applies to employers with 5 or more employees. And what the law requires is that you qualifying employers provide up to 5 unpaid days of bereavement leave upon the death of a family member. So what's a family member? Well, it's defined by the statute as a spouse, a child, a parent, a sibling, a grandparent, a grandchild, a domestic partner, or a parent-in-law. So that's not odd. We've seen other laws with very similar requirements or very similar provisions pertaining to what a family member is or is not. So anyways, up to 5 unpaid days of bereavement leave for the death of a family member. It is unpaid leave. Unless the employer has an existing policy that provides for paid leave, or if that employee has accrued leave, including vacation time, sick leave, PTO, and they elect to use that. So that's very similar to things like pregnancy disability leave, things along those lines. If the employees have the accrued time in place, they can use it to compensate for them. Now, employers are permitted to request documentation to verify that the need for bereavement leave actually exists. So what sort of documentation would satisfy this? Well, according to the statute, it would be things like a death certificate, a published obituary, a written verification of death, burial, or memorial service from a funeral home, burial site, crematorium, religious institution, or a government agency. So you can request that sort of documentation. If you get it, then the entitlement to getting this leave is granted. Bereavement leave does not need to be taken consecutively, but it needs to be completed over 3 months, within 3 months of the death, right? So if someone just needs a couple of days off this week because they need to meet with the funeral home, and then they need time off next week to do that, then they can. So it doesn't need to be taken consecutively, but all of that needs to be taken within 3 months. Okay. CFRA amendment. Now this is a significant one. And it's a significant one for several reasons. If for any other reason, it's not just the CFRA amendment, it also affects California's paid sick leave law as well. And the reason that it's significant is because, and this is going to be my first pitch, every employer in California should have some sort of employment policies or a handbook in place. And in fact, I would argue it's required. I mean, there are certain things that you have to have a policy about. You have to have a policy, or you have to have something in your handbook that addresses sexual harassment and sexual harassment investigations. And that's been in place since the mid 2015, 2016, you have to have that. So if you don't have policies in place, so you don't have a handbook in place that addresses those things, you need to get them in place. But it's one thing to just get them in place. So now you have them in place. Now you have to update them, because every single year we're getting things that are going to amend a handbook, that are going to amend a policy, and those amendments actually need to be made. And this is a good example. So what is CFRA? CFRA is the California Family Rights Act. And it is based off of, it's based on the federal FMLA, the Family Medical Leave Act. Here's the thing, the Family Medical Leave Act only applies to employers with 50 or more employees. CFRA applies to employers with more than 5 employees. So there's a huge discrepancy there. Now, even though CFRA was based on FMLA, and it was based on FMLA several years ago when it was originally adopted, they have really taken divergent paths. So CFRA is much more protective. So basically at its very core, it's much more complicated than this, but at its very core, it allows qualifying employees to take up to 12 weeks of unpaid pay to care for either themselves because of a serious health condition or because of a family member. Now, here's where these two laws, the federal law and the state law, have a huge divergence. Who you can take care for under FMLA is more narrow than who you can for CFRA. So FMLA, for instance, doesn't apply to a grandparent. CFRA does. So you can take 12 weeks for CFRA leave for a grandparent under this law, but you don't necessarily need to do that for FMLA. So if you're one of those employers that is more than 50 employees and the federal and the state law apply to you, it's very possible that you have an employee that takes their 12 weeks of CFRA leave for like a grandparent, and then they come back and 3 months later or whatever it is, they need to take their FMLA leave now because of a health condition affecting themselves. So here's the point. If you're one of those bigger 50 or more employee or employers, at this point when I'm doing model handbooks and I'm doing model policies, because if you qualify, you do have to have a CFRA policy in place. You do have to have a FMLA policy in place. I'm doing 2 separate ones for the bigger employers because I think that's the only way to do it. But anyways, let's back up and see what's going on here. So like I said, under CFRA, so this is the state law, you can take up to 12 weeks if you qualify to care for yourself or for certain family members. Well, what this law does is it now expands the list of individuals that you can take the leave for to include what's called a designated person. And even though this slide does say CFRA, like I said, it does affect paid sick leave laws as well. Those are now under our paid sick leave law. So if you remember, that's paid sick leave of 3 days or up to 24 hours, whichever is greater depending on how the person generally works. Who you can take that paid sick leave for now also includes a designated person. So what's a designated person? So under CFRA as it exists now, our list of people that you can take care for is a child, parent, parent-in-law, grandparent, grandchild, sibling, spouse, or domestic partner. Now it's going to include a designated person. A designated person for CFRA is defined as any individual related by blood or where relationship is the equivalent of a family member. Now, under the CFRA part, the employee can designate their designated person at any time up until the point when they actually need the leave request, right? So it's not something that they have to designate their person on the first of the year, right? If there's an issue that arises and they need to care for someone that they consider a designated person, they can designate that person at the time that they make the request. So do be mindful of that. Just because it doesn't, it's not. They're seeking protected CFRA leave, and it's not their parent or their child or themselves. It's just someone that was considered an aunt or was considered an uncle. That's who I think that would be very popular individuals that would qualify for this designated person. You need to be mindful of it. And we don't have, as of now, any sort of guidance on what the equivalent of a family member means. So it's very broad, and it's, for the most part, I would be very cautious if I'm an employer challenging an employee who says that this person is a designated person. I'd be cautious about that because we just don't have much guidance about it. Okay, so like I said, this affects not only CFRA, but it affects the paid sick leave law. Now, here's why that is important, because the definition of designated person under CFRA is different than the definition of designated person under paid sick leave, because the legislature can never make it easy, right? So under paid sick leave, a designated person is a person a person that is designated by the employee at the time the employee requests the paid sick day. And I'm quoting directly from the law there. Now, what doesn't that have? That doesn't have any requirement that the designated person be related by blood, and it doesn't have any language in there about being the equivalent of a family member. That's the language that exists for designated person in CFRA, for our CFRA portion of this law, but not for the paid sick leave portion of the law. So it's much more broad. So many takeaways here, but for your handbooks, at least, and your policies, if you have the list of people that, who are qualifying that you can take this leave for, and you should, it's going to need to be amended. And the amended for what a designated person is under CFRA and for the paid sick leave is going to be different. So do be mindful of that. All right. So before I go to the next one, yeah, I figured. Let's do it.
I got 3 questions for you, Aaron.
Yep.
12 weeks must be paid to the employee?
No, it's unpaid.
Okay.
It's unpaid, but of course, like I said, I mean, this goes back to when we were talking about bereavement leave. It's very similar. So if they have built up PTO, vacation, sick leave, there's various notices that have to be issued with a CFRA leave of absence. And if you're requiring the employees to take that, and you can require them to take that, that's one of the notices that you provide. So there are very specific regulations and model notices. I would recommend that you do that. And of course, if the employee wants to use it, they can as well. And I don't know why you wouldn't want them to. You probably would want them to exhaust any sort of accrued leave that exists at that point. Next
Okay.
one.
If an employee was on leave, say maternity during a holiday, but came back before the end of the year, are they entitled or must have pay any holiday bonuses that other employees were paid?
Uh, I don't, so this is my think here because I'd have to look at that up specifically. No, I do not believe that you have to pay for that holiday.
Okay.
But again, that's my belief. I had to verify that, but I'm pretty sure you don't have to pay for that holiday leave.
Okay.
Where people get in trouble is, and here's where it would be an issue, is that if you're giving CFRA leave, so you have one employee, well, your example is pregnancy disability leave, but that can of course fall under CFRA and FMLA as well. All these things work in relationship with each other. So you have an employee that goes out on their pregnancy disability leave, and then it ends. And then they have the ability to take another protective leave, and maybe they have like an ADA leave as a reasonable accommodation at the end. So here's where people get in trouble with that sort of stuff. Where okay, for the pregnant employee that's out on their leave, we're not going to pay them their holiday pay. But if it's another employee that's out on like a workers' comp leave because they got injured or something, and it's the same scenario, right? It's in the middle of their leave, we're going to pay them the holiday. So that's where a lot of that scenario, that's where I see the trouble is, right? Where people are being treated differently as far as their compensation when they're on a leave of absence, depending on what the leave of absence is for. So that would be a good example. Next one.
Bereavement leave is only for funeral service or grieving time?
Yeah, it's for the most part, I mean, it's a very broad statute. Um, it's to make final arrangements. It's to actually go to the memorial service, but again, it's somewhat broad. If you have specific questions, I don't know what they're contemplating, but yeah, it's to actually attend to this stuff, to deal with it. So I don't know if that answers that question, but hopefully it does. Next one.
Those were it.
Okay, got it. All right, so let's, actually, I want to see one thing here. Sorry, folks. Just trying to track where I'm at. Okay, workplace safety. So as the introduction said, this was my home agency. When I was in law school, I was what was called a judicial, I think it was extern, not intern, but extern. But I worked for Cal OSHA for 2 years. So this is where I got my teeth. So I worked for the appeals board. So if you ever get an OSHA citation and you appeal that, you appeal to the appeals board, and then they have an administrative law judge, which will decide if it was accurately or if it was correctly issued. And then if you don't like the decision of the administrative law judge, you can appeal confusingly to what's actually called the appeals board. And that is a board of 3 individuals who are appointed by the governor, and effectively they're like the Supreme Court of the Cal OSHA world. Those were the 3 folks that I worked for. So I was helping to write effectively appellate decisions, which was a great experience. And then just to let you know, if you don't like what the Cal OSHA appeals board does, then you can appeal it up into the court system, and then potentially actually get to the real Supreme Court if you wanted to. But that's my home agency. That's kind of, I I've always liked doing Cal OSHA stuff. There's, as far as I know, there's not a lot of us that here in California that actually do a lot of Cal OSHA work. And the reason is because a lot of the folks that specialize in Cal OSHA stuff or do a lot of Cal OSHA work, they actually came from the Cal OSHA world, right? And Cal OSHA doesn't, their appeals board does not have a very big legal department. I think when I was there was like 3 attorneys. So there's not a lot of us out there that actually have experience inside. But luckily I do. And so I've always been very interested in this agency. And they didn't get a lot of attention until COVID. And then they got a tremendous amount of, attention. So here we are. This is about workplace posting. So if you ever are unlucky enough to get a citation from OSHA, you actually have to post it in your workplace for a certain amount of time. There's additional rules if you're going to appeal it as well. So we now have a new notice requirement if a citation is issued. So this is in addition to actually posting the citation. So here we go with this law, AB 2068. And what it says is that you have to do an additional notice, and the additional notice is going to be something that the division prepares. So to their credit, when Cal OSHA does notices, usually they have a model notice that you can use. They're generally pretty good with doing models for notices, for like an IIPP, COVID prevention plan. But this is a notice that it's going to have to say this, that you're going to have to post, that the division investigated and found a violation, that an investigation resulted in a citation, that the employer has an obligation to communicate hazardous conditions to employees. And then it has to list contact information and for the division and the internet website where employees can go to search for citations against the employer. So I use the term division there. What's the division? That is the arm of Cal OSHA that is actually issuing the citations. It's called the Division of Occupational Safety and Health. The folks that actually create the regulations for OSHA is called the Safety or the Standards Board for California Occupational and Health. And then the Appeals Board is called the Appeals Board, of course. But the division, those are the folks that are actually you're having most of the interaction with likely as an employer. These are the folks that are coming out and doing the investigation, issuing the citation. Now, in addition to these notice requirements, the notice needs to be in English, and then it has to be in the, and I'm closely quoting the statute here, the top 7 non-English languages as determined by the most recent American Community Service by the U.S. Census Bureau. So I know now this is not in person, but I'm envisioning what you all are looking like right now. And if you're like any other presentation, I know your reaction, right? You're probably saying, I know the top 6 languages that are spoken in California, but that elusive 7th, I can just never find out. Well, luckily, like I said, the division is going to be putting together models. So they should have them in the models for the top 7 languages that we have here in California. So be mindful, if you get a citation, there's more posting stuff that you're going to need to do in that room where you have all of your other postings. COVID notice
Aaron,
requirements. Yes.
a question came in.
Yes.
Can you confirm this posting is only if you are cited by OSHA?
Yeah, absolutely. This is because it wouldn't otherwise make sense, right? Because the notice is saying the division investigated and found a violation, a citation was issued. So yeah, typically what works is that if you get a citation from OSHA, they'll do a closing conference with you, and then they're going to give you a packet of information, and it's going to have a packet of information with the actual citation, information about appealing the citation, which I generally recommend because usually most employers can negotiate a deal with Cal OSHA. I'm not saying all employers can, but for a lot of times, Cal OSHA is willing to negotiate, specifically about violation amounts. Usually it's very hard. It's harder to get the classification change from like a serious to a general or regulatory. But anyways, it has information in there about appealing and then also the postings that you're going to have to do. It would presumably, I haven't had any of my clients get a Cal OSHA citation since the beginning of the year, so I haven't seen it now, but it would presumably have this information as well. Okay, COVID notice requirements, and we are getting close to the end. So COVID notice requirements. So I have these slides in here because I like to remind employers in California that COVID is still very much a thing in California employment law. Now, maybe from the state government's perspective, as far as when the politicians are speaking, they're not really talking about, all the COVID restrictions that are still in place. And many of them, of course, have been repealed or they sunsetted or whatever. They don't exist. That is not the case for you employers out there. There are still plenty of COVID requirements that are out there that you need to comply with. And we'll talk about the Cal OSHA COVID regulations because that's the most specific stuff in just a little bit. But those regulations, those Cal OSHA COVID regulations, which my last count was, I think it was 11 or 12 pages, single spaced of regulations about COVID specific stuff. That just got extended in mid-December, pending state approval, which I have no reason to believe that they wouldn't approve it, and they probably have approved it at this point. Those got extended out to December 31st of 2024. So you've got several more years of COVID being part of your employment and your employees' lives and things that you need to comply with it. So that's the first reason I'm putting this COVID stuff in there. Other reason is because it is new laws. And so it does make sense to talk about them. So AB 2693. So there were certain duties that existed when there was an exposure in the workplace. There were certain notices that needed to be distributed to exposed employees within 3 business days. Things about disinfecting plans and cleaning plans, and notices to employees that they were exposed and whether or not they needed to quarantine or not, and under certain circumstances, notifying the local health department of the exposure or an outbreak or whatever it might be. Anyways, very onerous. Very detailed. The way that I was dealing with it for my clients was I just had a model notice that you would fill in the blanks and change some things here and there, and then decide who it's going to be distributed to. But it needed to be done within 3 business days, right? So it was very specific, and it was something that was very hard to comply with, I will say. But anyways, what this law does is it modifies that. So you can still do those person-to-person, notices if you want to, but the big takeaway is that you can now do a posting when there's an exposure in the workplace. So you don't have to do it to every individual, person-to-person notification. You can just do a posting. So what would the posting, would that encompass? So it would have to be issued within 1 business day of a potential exposure. It would include the date when the person that had COVID, those are called COVID cases, when the COVID case was on the premises, the location of the exposure. So that would be like the department, the floor, the building. It doesn't have to be so specific that it actually reveals who the COVID case was, right? Because there's still medical privacy that exists in California and in the country. So it doesn't have to be that specific, but for instance, Murphy Austin, we're on the 3rd floor and we're on the 8th floor. If the COVID case was only on the 3rd floor, I can put that. I don't have to, I don't have to put that it was also on the 8th floor, but I wouldn't say that the person was in the cubicle, like in the northwest corner of the building on the 3rd floor, right? Because that would kind of reveal who that is. And then you would also need in these notices to provide contact information for certain types of individuals. And those would be individuals that have, that would know about your COVID related benefits that you offered, what the cleaning and disinfecting plan would be, those sorts of things. And then that posting would be required to be posted for 15 days. Now, once again, employers need to, like many other records and documents and postings that exist in California, you need to keep a record of it. So you need to keep a record of, presumably the best way to do is just keep a record of, or just keep a copy of the actual posting itself. But you're going to need to keep that for some time, because Cal OSHA would ask for that. And I've had that scenario many times. Cal OSHA comes out, they're doing an investigation because you're a roofing company, right? And you had someone fall off a roof. Unfortunately, I've had to deal with that scenario several times in the last year. They're asking for the IAPP plan. They're asking for safety records, but they're asking for your COVID stuff as well. They're asking for your COVID prevention plan. They're asking for your COVID training. They're asking for your COVID exposure notices. So be very mindful of that. And of course, I've had some COVID cases that are actually filed by like private, like former employees as well. So this stuff is coming into play. COVID presumption. Yep.
Regarding the COVID poster, is that required to be put up in the office? And then the follow up to that, in addition, was the poster know your rights as well?
Okay, so 2 different things there. So the COVID, but it's a similar answer. It's basically you put it in the place that the employees usually congregate around, right? So a lot of folks, that's their break room or wherever, maybe there's a common copier or that's where the time cards are kept, whatever it might be. Um, for remote employees, you're providing this to them. If you have a digital, like an intranet, for instance, so it's a portion of the internet that only your employees could access, put it there, right? But yeah, that's generally for both of those things. For most of the notices we talked about, it's always the standard is always where's the place that people most commonly get together and they're going to see this, and that's where your posting needs to be. So, okay,
Okay.
is there
A
another
few
one?
more questions.
Okay.
Does COVID training have to happen yearly?
Uh, No, generally not. Now it does have to where this does come up, and okay, this is somewhat contingent on what the current COVID regulations look like. And if you've been up to date on this stuff, they've changed multiple times. But what has ended up happening is that the standards have changed, and when the standards change, it's recommended that you do new COVID training. So I'll give you an example of how it's changed. Um, what's COVID exposure? That definition's changed several times. What are basically the way that I would advise it is anytime that you're making any sort of change to your COVID prevention plan, and we'll talk about that in just a sec, I would recommend that you do some sort of training on that. I mean, it's a good record. Like I said, if CalOSHA comes out, it's just a good record to have. And for you contractors out there, just put it as part of one of your toolbox meetings or your tailgate meetings that you presumably are doing at least on a weekly basis, right? So just do that. So, but where additional training is required is so maybe you did training, a year ago or whatever it is, but you just hired a new person. Remember, that person's going to have to be hired or going to be trained on all of your safety stuff. So this is going to be a part of that, and you're going to have to keep a record of that. So that's how I would recommend approaching that. Okay. Any
Couple
other?
more questions for you on
Yeah.
this. Is the
hmm
COVID supplemental leave extended as well?
Yeah, I believe it's extended out or actually, no, excuse me. I believe it was extended out to December 31st of 2022.
Okay. And then somebody asked, willing to share with this group a model posting that you mentioned?
A model post, I guess depends on what the model posting is of what. The model posting of the EOC stuff, the COVID
I think
notice.
it was in relation to when you started talking about COVID and how you do a post, you helped create a posting for one of your clients.
No, unfortunately, folks, I do have that attorney-client privilege issue. So if you did ask me very, very specific questions about your workplace, I couldn't answer them. Um, no, to be quite honest with you, I haven't made one yet because I haven't had a client that's been in that position. Um, but I usually the first thing that I do is I'm going to guess that CalOSHA ends up putting out a model notice that you could take a look at. I just don't have one right now. So as soon as I get in that scenario, or in that situation, then I'll put one together. But unfortunately, no, I'm not going to put out a model notice just for the group. Sorry. Anything else?
That's it.
Okay. Uh, Presumption. Okay, I'm not going to spend much time on this. Basically, there was all these presumptions that exist for workers' comp purposes. So this law doesn't do anything that changes that. But here's what it was: is that employees that test positive during a COVID outbreak, and this is general. This is a general description of it. But if they tested positive when there was a COVID outbreak at work, they were presumed to have gotten that at work for workers' comp purposes. So what was an outbreak? An outbreak was if you had 100 or more employees, that was 4% within 14 calendar days. And then if you had 100 or less employees, that was four employees within a 14 calendar day period. So if that happened, there was a presumption, and there is a presumption because it continues on, that happened at work for workers' comp purposes. The nice thing about that law is that it only applied to someone actually made a workers' comp claim. And in my experience, at least, I mean, certainly I've come across situations where I've had employers where they've dealt with very severe COVID cases, but for the most part, people are not filing workers' comp claims. It does happen, of course, but it's not very common. But anyways, what this law did, AB 1751, is that this presumption was set to sunset here at the end of 2000. Um, um, 22, it's now been extended to January 1st of 2024. So you're dealing with it for another year. So be mindful. And before we go to the next slide, because I think arbitration agreements, here's my other thing. So like I said, with the Cal OSHA COVID regulations, on December 15th, 2022, Cal OSHA voted, their standards board voted to extend those regulations to December 31st of 2024, right? So it's quite some time. It's a couple more years. So what should you do with it? One, you should be aware that it exists. But those are the regulations that require you to have a COVID prevention plan. Now, there are some changes that are made in those regulations. The definition of close contact has changed constantly. But it, as it existed in the proposal that was extended to the state for state approval, it doesn't exclude or it doesn't include exclusion pay. So basically, under the Cal OSHA regulations, it was essentially mandating under certain circumstances for employees that got COVID at work, you were having to give them paid leave. This was in addition to the question that I just got about that supplemental COVID sick leave. This is in addition to that, right? So if this had got extended, maybe you don't have a law directly on that, but you might have a regulation. So now you don't, if these regulations are approved by the state. So what do you want to do? Presumably, if you have an up-to-date COVID prevention plan, it specifically says under certain scenarios, employees, you're going to get exclusion pay. Well, you would want to obviously modify that and amend that because presumably that's not a benefit that you're going to be providing unless you want to voluntarily provide it. And of course you can do that, but I presume most employers don't want to do that. So that's my pitch here. Update your COVID prevention plan. If I were to ask you right now, when was the last time that you updated your COVID prevention plan? And your answer included the word year or years. You need to update your COVID prevention plan because I can almost guarantee you it's not in compliance. So stay on top of this stuff. All right, any questions? Great. Arbitration agreements. Private Attorney General Act. So I mentioned this earlier today, PAGA. Private Attorney General Act, if you don't know, that's essentially a class action. So there's all these labor code violations that exist out there, and there's penalties associated with that. And only the state is able to recover them. Well, back at the end of the Gray Davis administration, when he was on his way out after the recall, he signed the Private Attorney General Act. And what that effectively does is it allows, if an employee gives enough notice to the state, it allows employees to effectively become deputized attorney generals and go off and get these penalties. And then once the penalties are recovered, 25% goes to the aggrieved employees, and the other 75% goes to the state. Here's the problem from an employer's perspective is that the employee's attorney gets attorney's fees. So what I am seeing is that employers or employees are not filing as many class action claims, because if you file a class action, there's certain requirements that you have to do to certify something as a class action. Well, that doesn't exist with PAGA for the most part because it's a different scheme. It effectively is a class action. It's a collective claim because it's brought on behalf of the affected employee and then all other affected employees. But all those class action requirements don't have to be satisfied. And even worse, say that the employee that's suing you, the named employee, their only problem is you didn't pay me overtime, right? My breaks were fine, but you didn't pay me overtime. Well, how this PAGA is so expansive that the employee in that lawsuit would be able to recover penalties associated with breaks that were not provided to other employees, even though the named employee doesn't have a problem with breaks. So it's a huge problem. And these sorts of PAGA claims, this is when you have like a pay stub violation. So say you don't have your employer name or your employer address on a pay stub, or maybe you don't have the pay period, or maybe the employee's ID number is not on the pay stub. There's certain information that needs to be on pay stubs. This is the sort of claim where employees are recovering hundreds of thousands of dollars before attorney's fees for those sorts of violations. So PAGA is just, from an employer's perspective, it's incredibly troubling. And as an employer's attorney, because I only represent employers, it's really hard to defend because a lot of it's what's called strict liability. If someone's pay stub for the most part is accurate or not. Does it have the employer name or an address on it? Well, if it doesn't, it doesn't, right? I mean, there's not much of a defense there. So anyways, one of the tools that employers had in their toolbox to deal with PAGA claims is to have arbitration agreements. But over the past several years, the California courts, including the California Supreme Court, had said any sort of arbitration agreement that is saying that an arbitration or a PAGA claim is subject to arbitration is void. And the reason being is that because it's not the employee who signs the arbitration agreement who is suing the employer. It is the state by virtue of the employee that has been deputized by the state to be an attorney general, a deputized attorney general. They're the ones that are suing the employer. The state is suing the employer, and the state is not the one that's suing the arbiter or is signing the arbitration agreement. So that had been the law for quite some time, but there had always been an argument out there that that conflicted with federal law. And so this is one of those rare situations where the US Supreme Court comes in and they're talking directly about state law and they're talking about PAGA. And that's what we got here, the Viking River Cruises case. So this dealt with signed arbitration agreements. And what the court said is that if there's an arbitration agreement between an employer and an employee can cover individual PAGA claims. So those are the claims that the employees suffered, right? They directly suffered. Those claims can be compelled to arbitration. But representative claims, those are claims that are brought on behalf of other employees, right? That can't be addressed by an arbitration agreement, but individual claims can. So there were a lot of questions that arose that are going to be clarified presumably by our court system here in California soon. But as it exists right now, and I don't think that this is going to change anytime soon, individual PAGA claims can be compelled to arbitration. What is happening is that the more sophisticated employers are, if they don't have an arbitration agreement, they're adopting arbitration agreements, or they are modifying arbitration agreements. So it's effectively having class action waivers in there. It's having language in there that says that if you have an individual PAGA claim, that's subject to arbitration to deal with this sort of situation. Because even though that doesn't mean that the PAGA claims go away, they still exist, right? The individual PAGA claims are going to have to be litigated in arbitration. That is much less lucrative for a plaintiff's attorney that's prosecuting that case. Why? Because the recovery is limited during that period. Now you're just talking about one employee, whereas when it's collective and it's talking about 100 employees or 500 employees or 25 employees, now it's all those other individuals, and the penalties are calculated by pay period over a year period. So the amount of recovery is drastically reduced. So they're not as, the amount of money involved is not as big for an individual PAGA claim. But there were open questions from the Viking River decision. The primary one is, okay, so you have an arbitration agreement where it says individual claims are going to be compelled to arbitration. What happens to the representative claims that presumably were filed in the same lawsuit as well? Are they dismissed? Are they stayed? Do they proceed concurrently with the arbitration in the court system? The US Supreme Court seemed to suggest that they were dismissed. It suggested that's not the holding, but that was the suggestion. And there was one of the justices had a separate decision that said that that's not the case at all. But anyways, that decision about what happens to the representative claim, that's going to be decided here by our California Supreme Court case in a few cases, but I've cited one of them here. I think this is the lead case involving Uber. What do you do in that situation? What is happening for most trial courts at this point is that they're staying the representative claims pending the individual claims being litigated through the arbitration process. But we'll get some clarification there. But regardless, this is definitely a tool for employers to deal with PAGA claims because you just don't have many out there. There is one where, like I said, the employee has to give notice to the state first. And there's a couple of pay stub violations that can be cured after that notice is given. So specifically, if the allegation is that a pay stub doesn't have the employer's name and address or the pay period on them, within 33 days of the notice being sent to the state, so this is before a lawsuit is sent, the employee has sent a notice of an intent to pursue this claim to the state. Within 33 days, if those issues are corrected, and they're very detailed as to how you correct those two issues, then they're quote unquote cured. Also, for my contractors that are unionized out there, because I've had this come up many times as well, does your collective bargaining agreement have PAGA waiver language in there? because there is a provision of PAGA that says that if a collective bargaining agreement has certain specific language, then PAGA claims are waived and they're dealt with under your collective bargaining agreement. Does your agreement have that? Go check that out, because I've been on both sides of that, and it is so painful when I'm dealing with an employer that is unionized and all of the additional obligations that a unionized employer takes on. You know, they're tremendous. And then there's lots of reasons why employers do that. Some of them just want to be unionized. Fair enough, but there's lots of legal obligations that are placed upon unionized employers. And if you have this tool in place where you can deal with a PAGA claim, um, you know, work with your union if you can to deal with that. Because I've had employers who are unionized that don't have the PAGA language in it. And guess what? They're dealing with PAGA claims. And there's not a great argument that, oh, I have a collective bargaining agreement, so we'll just deal with it that way, even though the collective bargaining agreement has this grievance provision in it. Okay, so we are almost done. Arbitration agreements and handbooks. So now we're going on a totally different topic. So now you're an employer and you're going to do an arbitration agreement. Some employers just would throw this in as a section in their handbook and then have their employees sign it. This is not a surprising holding from this court at all, but for the most part, that is not advisable at all. If you're going to do an arbitration agreement, do it as a standalone, right? I mean, there's several ways to invalidate an arbitration agreement in the state of California. You know, we do have a California Arbitration Act, so it's a state act that says, the state policy is that we, encourage arbitration and all that sort of stuff. But how it has been dealt with the courts, our California court system, certainly suggests otherwise. So there's lots of different ways to invalidate it, but this would be something that's procedurally unconscionable. So unconscionability basically means unfair, right? But if employers are just throwing in an arbitration agreement or arbitration language in a handbook, and an employee is just signing the handbook, agreeing to everything in the handbook, then that's not going to work, right? And there were a variety of reasons for that. If for no other reason, then employees may not read it. But the other reason is because an arbitration agreement is an agreement, right? It is a contract between two parties about how they're going to deal with a specific situation. And most employers would say their handbook, and they typically have language in their handbook that says, this is not a contract. We're not making an agreement here. Primarily they have that in there so that they keep the at-will presumption in California in place. But almost all handbooks, certainly the handbooks that I'm taking a look at, are saying this is not a contract. We're not creating a contract, employee, by you and signing this. This is just our policies that are in place. Well, an arbitration agreement is an agreement. It is a contract. So if you're putting an arbitration term in an otherwise document that you're saying that is not a contract, well, it's probably not a contract. So end of the day, best practice, make it a standalone agreement with your employees. Benefits.
Aaron,
Okay. Yep.
question came in.
Yep.
If we have a statement in our agreement that says, notwithstanding the foregoing, this arbitration agreement does not apply to claims that may be asserted by me under PAGA, does this language need to be updated?
Well, I mean, that's up to you, right? I mean, so I'm not going to tell, again, that's a specific quote from a specific agreement. So I'm not going to tell you specifically what to do. But the advisable way if you're going to do an arbitration agreement, there should be language. The language that I like seeing in an arbitration agreement is, if I have an individual PAGA claim, that can be compelled to arbitration. Representative claims, not so much, right? Obviously, you massage that language, but because those are the terms that the Supreme Court used, the U.S. Supreme Court. That's the language that I like seeing in arbitration agreements post the Viking River Cruises case. Okay. Next, any others?
No others.
Okay, and we're almost done, folks. CalSavers. So I'm not an employment benefits attorney. Murphy Austin does have a benefits. I do have one of my colleagues who specializes in benefits, but I put this in there. This is a benefits. This is a benefits law, but I put it in there because I don't think many employers know about this. So several years ago, we got the state created what was called CalSavers, and it said that for certain employers of certain sizes, if you didn't offer a retirement plan, you needed to enroll in CalSavers, which effectively was a way where an employee could take a deduction and enroll in this state program that allowed them to save for retirement. Effectively was a state managed IRA that you had to offer, right? Or you at least had to enroll in it and allow your employees to be involved in that. It wasn't mandatory. Employees didn't have to be enrolled into it, but it was something that was there, right? It's the point being to allow employees to save up when they eventually retire. Well, that threshold of qualifying employers that had to participate in Cal Savers has decreased over time. On June 30th, 2022, it was employers with 5 or more employees. Well, now we are down to if you have 1 or more employees. So presumably, if you're on this call, I'm going to presume that you probably have more than 1 employee. Now, if you don't have any sort of retirement plan in place, you're going to need to be registered with Cal Savers by December 31st, 2025. So just be mindful of it. I don't think a lot of employers know about Cal Savers, but it is out there. There's a lot. Cal Savers has a pretty good website, so you could go on there and get a lot more information. Like I said, I'm not a benefits attorney, so this is not something that I practice, directly with. I do have a colleague that does, but I didn't want to mention it because I don't think many employers know about it, and they should. They should. So with that being said, we're at the end. So are there any questions?
There are.
Okay.
So first one, about the
Mhm.
holiday pay requirement. How about if company paid out holiday bonuses? However, employee was on leave, PFL/FMLA scenario. Employee returns less than a month after bonuses were paid. Is company required to pay the employee who was out on the leave, or could we pay at company discretion?
Okay, so you're gonna have to email that question. I'm gonna have to look. That's pretty detailed.
Okay.
I don't think I can generally answer that question. So we're getting pretty detailed there.
Yep.
Okay, next one.
And then the pay back to pay discrepancy. Are employers required to pay drive time to and from job sites, even given company vehicles?
Drive time? Yes.
Yes.
Okay, so here's the rule. Um, so I'm assuming it's a construction company. If you have your employees report to a central site, so like your shop, and then from there they travel from shop to job site, that time's compensable. Now you don't have to pay, like say you're paying your employees $30 an hour. You can pay drive time at a different rate of pay as long as the employee you let your employees know in writing that that's going to happen. So what a lot of construction companies will do for that drive time is they're paying minimum wage for that drive time. But of course, you're going to have to be pretty particular about what your time records look like to do that. Now, if the employees have the option to carpool, right? So they have the option to come into the job site and then hitch a ride in. Um, that is not necessarily compensable. Where it's when it's required, and where employers also get in trouble in is that. And I had a case. This is one of the first cases that I dealt with, and I've been doing employment law I think for like 16 years at this point. But it was an employer where it was an option. You come into the job site and you can hitch a ride, right? So folks would come into the job site, and these were crews of like three-member crews, right? And only the foreman or only the lead needed to drive the truck to the job site. Well, the problem is that the crews were composed of family units, right? So the lead was like the uncle, and then it was like 2 nephews or something like that. And so what would happen is that maybe the 2 nephews, so the 2 helpers, if you will, didn't have to come to the job site, but they did come to the job site, and they felt compelled based on family relationships to help out their uncle. So now they're working, right? And so that's time that needs to be paid. And that time from there to the job site needed to be paid. So you need to be mindful if you're doing drive time, if they're required to come to the job site or to come to the shop, that's easy. They got to be paid, although you can do it at different rates. It's when you're giving that, you're saying, oh, you can come here if you want to, and you got to be very mindful if they're actually doing something during that time, because that's where that switch of being just, basically carpooling and it doesn't need to be compensated to being compensable comes in. Next one.
Are union employees included in the count that for the pay discrepancy?
Yeah.
Yes. Okay. And then what about bonus pay under that pay discrepancy?
Yeah. So like I said, the labor commissioner says, and let me go back to my notes there so I can get the specific language. It was, so according to that FAQ section that they put on, it says it's only a pay scale. It's not for additional compensation or tangible benefits. So it depends on how your bonus program is set up as compared to being discretionary and non-discretionary. But according to the FAQ from the Labor Commissioner, it's just the pay scale. So if there's some discrepant or like a Christmas bonus or something like that, presumably that doesn't need to be in there. I mean, perhaps under some scenario where it's a non-discretionary bonus, that's almost comparable to a piece rate type thing. That might be the case that you would need to put it in there. So I guess
Okay.
it depends on the bonus. Yep. Next one.
Next one, are you going to talk about California privacy law?
No, I am not. And the reason I'm not going to do that is because that is a 2-hour presentation. There's no
Okay.
way that we can do justice to that, but it is something that you should be mindful of. California Privacy Rights Act is something that has existed for several years, and it just pertained to consumer information, but it's now starting to creep into the employment world. So some employers are asking me, well, can I just put a provision in my handbook that deals with California the privacy rights? Because it is such an all-encompassing law and it expands beyond just employment stuff, what I'm doing is I think employers, if you're falling in underneath that, there's a few specialists or people that really work hard or consultants with this. I'm hooking you up with those folks just because it involves consumer stuff. And employee stuff and all this other. It's just such an expansive law, but what. It's just a nightmare. It's very hard. It's very confusing. We did do one presentation at the very beginning that involved that, and it was like 30 minutes of this presentation. So no, I just don't have the time to do it, unfortunately. But you should be mindful of it if you're meeting those economic benchmarks, that it will affect not just your employees, but it will affect a lot of the way that you operate your business.
Is there any change in sick days law, in the sick days law?
Yeah,
Sorry.
well, the designated person aspect of it, right? So you can take, so the paid sick leave law is the law that's 3 days or 24 hours. And that's been in place for, I think, about 5 or 6 years at this point. So the big change there is that you can now take that for a designated person as well. So that's the change.
Okay. And then back to the benefits one.
Cal
Is
Savers, yeah.
is yeah, exactly. Is a simple IRA good enough?
So you should talk to the broker that is actually providing that IRA.
Okay.
If it qualifies or not. I know a lot of employers deal with it that way. I'm on some, like I said, I'm not an employment attorney or a benefits attorney. I am an employment attorney, but not a benefits attorney. But I know of several employers that have dealt with that. Effectively, they open up a system where it's some sort of IRA that the employee can contribute to. So I would just talk to your broker about it, or if it's through a bank that offers it or whatever. But again, just generally, if you offer some sort of retirement plan, and certainly an IRA would be some sort of a retirement plan, then CalSaver isn't going to kick in. And actually, that's what a lot of employers do to avoid CalSavers. But to get the definitive answer, you need to talk to your provider specifically, and they should know about this.
Okay. And I'm assuming a question just came up in just as you were talking. Are commission only employees allowed? And I'm assuming that's around the IRA question.
I'm not aware of any exemptions
Okay.
for employees.
And then for the CFRA,
Yeah.
does the employee have to be employed for more than 1 year, or are they eligible since first day of employment?
No, so it's they have to work. The threshold is 1,250 hours within 1 year. Now, it depends on how you measure the year. Is it measured by calendar? Is it fiscal years? It's based on when they start their employment. But that's the threshold. So that is yet another pitch for why you need to have a handbook, because it would define what your year is.
Perfect. And then it's a comment, not a question, but Cal OSHA
Mhm.
has a model notice on COVID on their website.
Hey,
So
there you go. There you go.
yeah.
All right,
Believe
anything
if
else?
anybody have any more questions, this is the time to ask. Otherwise,
Yeah,
I
as
will
we're
just
waiting a few minutes, I'll do my pitch. Right. So Murphy Austin does have several resources that are available if you're interested. So we do have just an employment not law newsletter, which is quarterly. My benefits colleague does a blog about benefits that you can get. Client alerts, so if something like, huge happens in employment law, we would do like email blasts. We did this during COVID, like every single day. But the pitch that I'll put in, because it's actually what I do, because I do it, it's the podcast. So it's my podcast. It's once a month. It is almost always under 5 minutes, and I quickly just try to hit some sort of relevant topic in employment law, and I try to do it in a non-boring way so that I can keep your attention. So like the last 2 months have just been about new laws, so very similar to what I did here, but obviously in a much more condensed fashion. This month, I'm almost positive I'll do it on the pay discrepancy labor commissioner FAQ section and see what they have to say. So if you're interested in being signed up for any of that stuff, I can imagine that, or I would imagine that you're able to just send in your information here to Bender, and they can get that off to me, and we'll just signed up. So with that being said, I'm done unless I have more questions. So we got anything out there?
There was one more question that came in, and it asked 1250 was for FMLA. I thought it was different for CFRA.
CFRA? No, it's the same, 1,250
Okay,
hours.
perfect. I'm going to close it out right now since we're at 10:30, Aaron.
Right.
I
Let
want
me
to
just
thank you
let me just say
again for sharing
let
with
me
us
just
today.
let me say one more thing. So
Oh, yes.
SEPA is much more complex as far as
Okay.
qualifications than just that, but that is the base number of hours within a given year. So there's many qualifying factors in there. That's just one aspect of it. So go ahead.
Perfect.
Besides, well, before you do your thing, I do want to say, because we're at 10:30 right now, there was a discussion yesterday when we were doing our tech talk or a tech prep, whether or not we were going to go beyond an hour. So obviously we did. I want to thank everyone. I can't see any of you, but I do hope that this was informative. I hope that it was helpful, and I hope that I was not too boring for you, because this can be somewhat dense. But I want to extend my appreciation to each and every single one of you, and thank you for your time this morning.
Well, I want to thank you again, Aaron, for sharing with us today. We appreciate you all for taking time out of your busy schedules to join us for today's Bender U. As a reminder, this session has been recorded, and a link to review and share the recording will be emailed to you following the webinar, along with a copy of today's slide deck. Should you have any questions that arise after our webinar has concluded, please feel free to reach out and we'll be happy to help. Thank you again, and we hope you have a wonderful day. Thank you, Aaron, and everyone. Goodbye.